All right. Let me go ahead and play the next video while I
Mhm.
have internet. Not rushing, just I know the internet is going in and out. So I apologize in advance. It's going in and out today because Agent Johnson don't like subjects like this. So going to trial.
In 1837, Emerson was transferred from Fort Snelling to Louisiana, but he left the Scott family behind in Fort Snelling to lease them out to other officers. While in Louisiana, Ole Emerson, he meets and marries Eliza Irene Sandford. Eventually, they were reunited with the Scotts up in Fort Snelling, and then they all moved back to Missouri in 1840. You'll remember, Missouri is a slave state. Anyway, Emerson suddenly dies in 1843 at the age of 40. The official cause of death is consumption, but rumor has it was syphilis. Emerson's widow Irene gets his estate, so she leases out the Scots' labor for the next 3 years. At this point, Dred and Harriet have 2 girls, Eliza and Lizzie. In 1846, Dred tries to purchase freedom for himself and his family from Irene, but she was like, nah, that ain't happening. And so that same year, Dred starts the legal proceedings that would eventually lead to the Supreme Court decision that we're talking about today. The first case Scott filed was in Missouri State Court, and he relied on the long-standing Missouri judicial standard known as once free, always free. The standard allowed slaves who were taken to places where slavery was outlawed to then be freed, even if they returned to the slave state of Missouri. His wife Harriet filed a separate lawsuit for her own freedom as well, and the 2 lawsuits were later combined into one that represented the whole Scott family. They were assisted in the initiation of their suit by a guy named Francis Murdoch, a white attorney who filed nearly 1/3 of all freedom lawsuits in St. Louis between 1840 and 1847. He initiated the lawsuit and paid the fees necessary for its initiation. He relied on the once free, always free judicial standard, which again was long-standing and well-established by numerous court cases, all the way up to the Missouri Supreme Court that allowed enslaved people to sue for their freedom and win. He likely would have told the Scots that they had a strong case. It met all the requirements. The problem is that the judicial standard no longer reflected judicial and social attitudes about slavery by the mid-1840s in Missouri. Remember, we're 15 years away from the Civil War, but things are already boiling over. Between 1844 and 1846, 25 freedom lawsuits were filed in state court in St. Louis. Only one had resulted in freedom. Murdoch moved to California before the Scots case went to trial, and at this point, for reasons that are still unknown, the Blow family, that original family that owned Dred, remember? The guy Peter, he had 7 kids. Yeah, and his kids started getting involved and supporting the Scots suit. It's thought that Charlotte, one of his daughters, was the matriarch in the family and persuaded her brother-in-law, a prominent lawyer named Charles Drake, to assist the Scots on their case. And then when Drake moved away, Charlotte got the attorney for the Bank of Missouri to represent the Scots. Charlotte's husband, you see, worked at the bank, which is the only apparent connection that would make sense for this random bank lawyer to have gotten involved in this case. I point this out to again highlight the many hurdles that enslaved people had to overcome to get a freedom case brought to court. That the Scots were able to initiate their cases was due in part to their tenacity and bravery, but also in part to a community of people who helped. A lot of stars had to align for this case to have even started.
Yeah.
That last sentence, and I'm gonna bring you to thinking about George Floyd. The stars have to align for the black person to get justice. Okay? Luck has to happen in order for you to get close to justice, and then the outcome is still uncertain.
The thing that sticks out to me in that last one, it was at the very beginning, was you have the laws, your laws on the book, once free, always free. And yet I'm with Thea's on this, is that during that time, these times, anything else, man is gonna man. And although the law is right there in front of you, the ones that you wrote in black and white, but I'm not feeling it. I know what I wrote, I know what I said, but no, I'm not feeling it. 20
Somebody else wrote that.
25 cases. You won 1 out of 25. Just because you ain't feeling it. And it probably is what this is saying. I didn't write that law. I don't even know how long this law been on the books.
And well, hey Marlon,
Yeah,
and doesn't that sound real similar to today?
yes, that's why I'm bringing it up.
I don't like them laws. I don't like them. No, not them right there. No.
These are the strong. These are the people who Constitution, the strong Constitution.